All right. The next case on the docket, Orlando Property versus Bank of New York Mellon. Well, if there are no further questions and nothing else that you'd like to say, we can move on.
Thank you, Your Honor. May it please the Court. My name is Richard Mockler. I'm
sorry,
here.
give us that again.
Richard Mockler, M-O-C-K-L-E-R. I drove over here this morning from Tampa. I'm here for Mr. Stopa on behalf of the appellant.
Have you filed a notice of appearance in the case, Mr. Mockler?
I have, Your Honor.
Did you do that this morning?
I did, Your Honor.
Okay. All right.
And I've presented a copy to opposing counsel. Okay. I would have filed the notice of appearance yesterday. However,
no
I had to go through the registration process.
No problem. Go ahead.
And that was granted this morning at 7:50.
Right.
So this case is important for a number of reasons.
And you tell us that for the proposition that justice never sleeps?
It was early. I was very happy the registration was granted.
Right.
So I could represent to the court that I had formally appeared in writing.
Okay.
What's important about this case? There's a number of things that are important about this case. How does interest priority for a lien or an ownership interest fit into the rubric of pleadings in a foreclosure case?
Well, I would perhaps rephrase the question as whether the superiority of a mortgage is a prima facie element of the cause of action.
And that in and of itself is part of the question of how it fits in, because
Is it?
It is. I would submit that it is.
You think that if I've got a mortgage on a piece of property, I hold a first mortgage on it, that part of my cause of action to foreclose upon that mortgage is to show that it's superior to a second or subsequent mortgage?
Absolutely. And if we didn't do that, we'd have a significant problem.
Yeah. Go ahead, convince me of that, because that's a hard sell.
Well, Your Honor, that's sort of what happened in Lemaire, which is a Florida Supreme Court case, where you have a situation where an association or a second lien holder can file an action for foreclosure, right, without having to make any allegations regarding superiority. They claim, they plead everyone in the case, including perhaps even a superior lien holder or a mortgage holder, and they take a judgment which the bank or the superior lien holder may or may not be aware of, and the bank now, if it's by default or however, is faced with seeking to void the judgments. And by not requiring a party...
Was the bank given notice of the cause of action?
Many banks are given notice of...
I'm not talking about in this case. I'm talking about the case that you're citing for authority.
They defaulted and they failed to respond, and they found themselves a year later trying to reverse a decision where a lower priority lien holder...
That's not the factual situation here.
But
this isn't a default and an effort to set aside a prior final judgment. Here we have an initial action for foreclosure.
Correct.
Where you've got a first mortgage holder...
Correct.
...who seeks to foreclose, and then you've got a subsequent purchaser, and your argument is that the bank has to prove their priority over the subsequent purchaser, right?
That is exactly it, Your Honor. And I'd like to talk about that just for a second.
Well,
because
let's talk about it for 20 minutes.
There's 15 left. I asked to... May I reserve 5 minutes for rebuttal?
Sure.
I didn't formally state that. I apologize.
That's my default.
So, in the complaint itself in this case, paragraph 14 recognizes Orlando Property and states affirmatively, our interest is superior to any interest or claim that Orlando property.
They pled that, but the
They-
question is, really, you can plead a lot of things, but that doesn't mean that during the course of establishing your prima facie case that you need to prove everything that you put in your complaint.
It's not, but it's, you would, I would submit, Your Honor, respectfully, have to plead what you want in your judgment. And the Florida Supreme Court has issued in 2010 Form 1.996, I believe, which is a Florida standard foreclosure judgment, right? It's in the forms. It's adopted by the Florida Supreme Court. The second paragraph of that is, we have superior interest over all other parties.
Well, that could be because the subsequent purchaser, either whether it's a second mortgage holder or a subsequent purchaser of the property, didn't prove their affirmative defense of a superiority of their mortgage.
But, Your Honor, I would submit that the form judgments normally don't include affirmative defenses. To be fair, affirmative defenses don't show up in form judgments. That's part of the case that you prove to, and the Florida Supreme Court adopted this in its form.
If you've pled, you've got a first mortgage, and assuming that the superiority of a subsequent mortgage is an affirmative defense, if you don't prevail, then ipso facto, the first mortgage is a superior mortgage, is it not?
The question is whether it is an affirmative defense at all and who has the burden to prove it, right?
That's what we're talking about.
And that's one of the things that this court, in Your Honor's opinion, found in, I believe it was Black Point Assets, very recently, where the court found because every complaint seeking foreclosure necessarily alleges that the plaintiff's interest in the property is superior to the other party's interest being foreclosed. Now, interestingly, the court found that in the context of stating that there was no failure to state of cause of action by failing to plead or allege. But in this case, whether it's subject to dismissal or not, you have to show, it's incumbent upon you to show that you have the superior interest if you're going to submit a judgment to the court and ask the judge to make that finding. And here, the judge is making a finding for which there's no evidence. It's void of evidence as to that point.
What if the complaint simply alleged that OPA has an interest in this real property, and you're joined because you may have an interest in this real property? They don't affirmatively, the plaintiff, do not affirmatively allege our interest is superior to yours, but you're joined in because they want to wash out what any lien holders on this property.
And then you get it.
Come in and you OPA legitimately think that your interest is superior for some reason that, whatever reason, I guess we don't have a record of it, we don't have any evidence at trial about this. And you plead that, no, my interest is superior. Wouldn't you have the burden in those under that pleading scenario?
If that were the fact pattern here,
Well,
but
I know, but so you seem that you put significance on the fact. I mean, I guess if I was a plaintiff's attorney or a bank's attorney coming out of this oral argument, I'd say, don't ever use the word superior in any complaint forever and ever again, because that'll make it, that'll put the onus on any defendant who ostensibly has a superior interest to raise that, and then that will be your affirmative defense, and then that will be your burden of proof.
well, that would be that would lend us to the situation that we had in Hidden Ridge, where nobody puts any evidence in regarding superiority, and then the Fifth District, 3 years ago, is sending cases back because nobody talked about it, and now we're creating confusion. And what's the public policy of that? Where now we just leave it out and we ignore it like it's not a real thing, right? Nobody has to plead it. You don't have to do any 57105 analysis to even determine whether you're actually, a superior interest and whether it's actually proper for you to bring your action. And then.
But I mean, in this case, they've alleged that your interest arose out of that there was a 2013 Orange County case, and you have some kind of unrecorded certificate of title.
That is the allegation.
Okay, and then this mortgage on its face is a 2006 mortgage, right?
Correct.
In our case. So you're
Correct.
wanting us to send it back to say, okay, have a do-over, somehow show how the 2013 certificate of title has superiority over a 2006 first mortgage.
Well, even talking about the 2013 is interesting because that's not in evidence.
No, I know, I understand, I get
And
the argument, I would say, but it was pled that. So we're looking at what's in our record. There is a pleading that says your interest comes out of a 2013 case.
Correct?
Which chronologically would suggest that it's inferior to the, I understand it's not evidence. I was a trial judge at, many eons ago, so I understand. I get evidence and all that stuff. I've heard about that. But now here we are. You're asking us to do that, to have a do-over. So, and granted, I think plaintiff's attorney could have done a better job here and avoided this discussion we're having this morning. But that being said, that's the end-all, be-all of what you want us to have done.
We would like the court to require that the judgment that's entered and the findings that are entered are supported by some kind of evidence, and in this case, there was particularly none. Which brings us to another important issue is what is judicial notice, right?
Seems like it's a misunderstood concept amongst a lot of
and
lawyers.
that's something the court could clarify today, which would be important.
Judicial notice is not evidence.
Judicial notice can be evidence,
Well,
but
I mean, things have to be put into evidence. The fact that, they come in and say, Judge, we want you to take judicial notice of this court file. Had that all the time when I was a trial judge. I said, okay, there it is. I'm a judge. I notice there's a file here.
It's exactly what happened here. There's a file, no reference to a specific document, no effort to move the document in, no certified copy of the document.
That part I'm with you on here today.
How is an appellate court supposed to do its job when we make a blanket request? Now that's important. It's a request for judicial notice that wasn't granted. We can't miss that point. Judicial notice wasn't granted. Judicial notice should occur, and I have several cases that say this, judicial notice should occur by moving the document into evidence or referencing a specific document and having the court grant the request for judicial notice. In this case...
if you want to be hyper-technical, don't you have to file a timely motion to have you take judicial notice, attach certified copies of those documents of the court file to that motion so that the trial judge is able to look to see what wants to be judicially noticed, and then we as an appellate court, if it comes up for review, we know actually what was from that other judicially noticed file that was in our record so that it's part of our appellate record that may factor into our decision. Isn't that, you want me to write that down and put an opinion?
That is absolutely should be, interestingly, I have cites for that, because that's what other districts have read. But the other concepts are at least waivable. Like if you didn't have certified copies, that's waivable, right? The other things are
yeah, I know, but I mean, from a technical standpoint, yeah, I mean, you can stipulate that, yeah, it doesn't need to be certified, that's a true, I understand.
This is interesting because when you read that, we asked the court to take judicial notice of the entire court file. This certificate of title is in another court file. And the request for judicial notice that was actually filed talks about the court file in the instant case, but that is in another case. And what's the only reference in the record in this case to that certificate of title is their pleading, and we know well that pleadings are not...
I mean, I tend to agree that the evidence presented by the plaintiff is somewhat, maybe not as thorough as one would have hoped. The issue, though, is more of the legal issue today, is whose obligation was it to plead and prove that, isn't it?
It is, and there's a number of cases cited in the briefs. Sotzchen, and I believe it's...
Yeah, we have a number of cases out of our court where we've discussed the involuntary dismissal in that context, where we've reversed for that.
making the obligation to meet the standards of the Florida Form Supreme Court judgment and the element, or in this, I guess this court's previous, Blackstone says it's not an element for dismissal purposes, but having the correct party and the correct establishing the priority of any liens, which is how we got the cluster that we have in Hidden Ridge, where people went to trial and nobody said whose lien was superior, nobody put any evidence in it, and now the condominium association and the lender are at odds, and we have to have an appellate decision to tell them to go back and have a do-over because nobody talked about it. But it's critically important that
There was no factual dispute in this case that the first mortgage was predated your clients, any rights your clients asserted.
that paragraph was denied in the pleadings, and that is the same thing that brought us to, in the Hamilton case, where it was denied, and Saatchi.
Are you suggesting that there's an actual issue as to the timing of your clients? Did your client get this out of foreclosure, or I'm trying to remember the exact context under which your client obtained an interest in the property?
That was in a separate court action.
What type of action was that, do we know? The certificate of title that your client had,
It's nowhere in the record, Judge.
not in the record.
Nowhere. The only reference is in the complaint, and after evidence was concluded, and they never sought to reopen the evidence or put it into evidence or anything of the sort, they said, well, the court can take judicial notice. Judicial notice was never noticed, never requested, never granted, no document was submitted, which are all important things to do when you're seeking to have someone take judicial notice. And so in this case, we're all arguing in a vacuum about something that was pled, never proven, no judicial notice, in the judgment. So the court's making a finding that by definition, there's absolutely no support for.
How did your client obtain an interest in the property?
I don't know.
Okay. Then you're into your rebuttal time, and we'll go from there.
I'll stop. Thank you.
Okay. You can come closer. We won't.
I was just grabbing my back.
Oh, all right. We'll try to not throw anything at you. Okay.
Good morning, may it please the court. Dariel Abrahami with Greenspoon Martyr on behalf of the appellee. Did the bank state a prima facie case for foreclosure? Yes, it did. Did they prove it at trial? Yes, they did. What are the elements to state a cause of action for a prima facie case for foreclosure? You need to have a mortgage agreement. You need to have a default. You need to have an acceleration to maturity, and you need to prove the amounts due. The bank did all of that at the foreclosure trial.
Did the bank plead that their interest was superior?
The bank pled in the complaint, and that's important here. Yes, they did. They pled their interest.
Did they prove it, and if so, how?
Yes, they proved it, because you have to go back to the pleadings. The issues at trial are framed by the pleadings, and that's why it's important to look at what the complaint said, what the answer said, what the affirmative defenses said, what the amended answer and affirmative defenses said. Because if you look at that, you'll see that the bank proved its interest was superior to whatever interest.
Did you have to prove it by evidence at a trial?
They proved it in evidence because the mortgage was entered into evidence, and the mortgage was recorded in 2006. And the burden then shifted to Orlando Property to prove that it had a superior interest, because you have to look at the pleadings, because it's unclear what interest they're claiming they actually had.
Well, but you bring them into the lawsuit, you plead your interest is superior. If they simply file an answer, say, I deny that paragraph 8 allegation, whatever, period.
Kind of like the answer to the last question. I don't know.
Well, in this case, Orlando Property, that's why it's important to look at the pleadings. They denied that they were the owner of the property by admitting that Valkov is the owner of the property. Valkov is the owner of the property. Orlando Property admits that. Then there's an allegation, I believe, in paragraph 14. Orlando Property may have an interest or lien on the property by virtue of an unrecorded certificate of title recorded in 2013. Denied. They're denying that they have any interest in the property. So what does the bank have to...
They're denying your allegations in the complaint.
No, not necessarily. In Rule 1...
I say denied to your, if you plead something in paragraph 8 and they put in their answer paragraph 8 denied.
In Rule 1.110C that discusses answering complaints, if you're going to admit and deny allegations, you need to admit that portion which is true and deny the remainder. Here, if they're going to claim that they have an interest in the property all the way through the case in that trial, they need to admit the portion of that pleading that says, we admit we have an interest in the property, however, we deny that we're inferior. OPA didn't do that in their answer. Then they had a chance to fix it when they filed an amended answer in affirmative defenses, and they didn't fix it. When we came to trial, or when the bank came to trial, the bank didn't have to prove that its interest was superior to a 2013 certificate of title because OPA denied they had any interest. Therefore, when the bank came to trial and the mortgage was entered...
Why would you go to trial? Why wouldn't you get summary judgment? If they claimed, if you thought that that was the status of the case, you'd file a motion for summary judgment, and you'd go in for summary judgment.
I can't answer that question. It would be speculation.
You were not the trial attorney?
I was not the trial attorney. A lot of cases are tries these days because the standard is high on summary judgment. If there's any issues of fact, they get reversed, and a lot of cases go to trial. But I was not the trial attorney. I didn't make that decision. I'm just trying to argue what happened at the trial.
So once you allowed that issue to go to trial, once you went to trial, haven't you waived your right to complain about the fact that they have no interest in the properties?
No, we haven't waived it. And if you actually look at the trial transcript...
Allowing that issue to be litigated, basically.
Well, at trial, if Orlando Property is going to claim at trial that they now have an interest in the property, any interest they may have acquired, since they denied any interest in the answer, must have been acquired during the pendency of the foreclosure action. And if it was acquired during the pendency of the foreclosure action, it would obviously be subject and inferior to a mortgage that was recorded in 2006.
So you're saying if I'm joined in as what the plaintiff believes is an inferior lien holder to wash it off the property in foreclosure, and if I admit that, yes, I do have an interest, but I deny or I'm without knowledge as to the remaining allegations of the paragraph, whatever number it is, that has now caused the defendant to prove the superiority of his or her claim?
No, if the defendant admits they have an interest...
I have an interest, and I'm without knowledge as to the other allegations of that paragraph.
Then the bank would be required to prove that it has a superior interest to...
By actually putting on evidence at a trial that says, I mean, obviously you put your note and mortgage in, so that's step A. Step B, then whatever that other interest is that you want to wash out, that you pled that you're superior to, you have to present that and show it to the judge. Here's a 2013 certificate of title. I have a 2006 mortgage. 2006 is earlier in 2013. I win, right, Judge?
I would agree with that, Your Honor.
And that's kind of missing around here, isn't it?
Let me make sure I understand. Then you do not take the position that they would have, as an affirmative defense, to show that their mortgage or their whatever interest they have in the property is superior to yours.
In this particular case...
Now, I'm asking as a general legal proposition.
As a general proposition, if they're denying the allegation that it's superior, that the bank's mortgage is superior, then I believe the burden would be on the bank to prove that it's superior. If it specifies...
So you're relying upon the fact here that they denied having an ownership interest?
I'm relying on the fact that this was a gotcha tactic at trial, and they denied having any interest in the property whatsoever. They admitted that Valkov was the owner of the property, and then they show up at trial, and after the plaintiff rests its case, they try and assert we're moving for dismissal because now we have an ownership interest or whatever interest they may have. We're not saying when it was acquired, and the court should dismiss because you failed to prove something that we denied in the complaint, or admitted that we didn't have an interest in the complaint.
You're saying in their pleading they denied having an interest in the property.
That's correct. They did. They denied it. So it's exactly what Your Honor's example was at the beginning of the case. If you just left it off, they have an interest in the property, period, and doesn't specify that it's inferior or superior, there's nothing left to prove. The mortgage was entered into evidence, and then the burden would shift to them to come and prove.
And you're saying if there is compound allegations in your paragraph that you as a defendant you can't just blanketly, you have to admit some and deny some as the facts may be. As
Rule 1.110C says it. It says when a pleader intends to deny only a part of an averment, the pleader shall, which means it's required, shall specify so much of it as is true and shall deny the remainder. It's not optional. If part of the allegation is true, they need to admit it. If part of it is not true, they need to deny it to frame the issues in the case and frame the issues for trial. Separate and apart from that, I'm obviously asking the court to affirm the final judgment. But if the court is inclined to reverse for whatever reason that neither party proved superiority, then the proper remedy would be to reverse and remand to have an evidentiary hearing to prove who's superior. And there's two cases out of the 5th DCA that stand for that proposition. There's the Hidden Ridge case, and there's also a case from December, which we filed as supplemental authority, which is the Bank of New York Thompson case, and I believe, Judge Lambert, you sat on that panel, and
They can't blame me for everything around here.
and this was the same law firm that represents Orlando Properties, represented Jupiter Homes, who had, because I read the briefs in this case, the opinion is one page and is very short. And in that case, the court involuntarily dismissed the action at trial because the bank didn't prove its interest was superior to Jupiter Homes, who admitted in the complaint that they were the owner of the property. And there was no proof as to whose interest was superior, and the case was involuntarily dismissed at trial. It came up to the 5th, and the 5th reversed and said it needs to be reversed and remanded to prove who's superior, and that the bank satisfied and stated a cause of action for a prima facie case for foreclosure. So while I'm asking the court to affirm the judgment, I'm asking the court, if it's inclined to reverse for whatever reason on this issue, it should be reversed and remanded for an evidentiary hearing on the priority issue. And at that point, it will be established that the bank's mortgage from 2006 is superior to the association's interest, which this is one of the things that happens in these cases, is that these people and these parties and entities that acquire title at these lien foreclosure sales, they hide the ball. They are very, very.
Well, I mean, okay.
And I don't want to get into it, but they're.
Let's get into it a little bit. I mean, you plead it, so you have some you, the bank, at the time you file the lawsuit, you have some information as to what their interest is. I mean, there must be a title search or some document that says, okay, these guys might make a claim here. So you physically have a piece of paper. So all you really have to do at trial, hiding the ball or not hiding the ball, or whatever other euphemism you want to use, all you got to do is present that document into evidence. If it's a certified copy of a public records, that can get in without having to call the clerk of the court, and you give it to Judge McIntosh and say, hey, mortgage, old one, judgment, earlier and newer one, this one's goes over this one. There's your proof. 30 seconds. And please, if you're not a trial lawyer, would you please tell your plaintiffs judicial notice is not some end-all, be-all to everything. Somebody actually has to come to a judge and say, Judge, physically, I'd like you to take judicial notice of this, follow the statute, and then physically move that into evidence, because evidence is what drives a case, not this 90.201 judicial notice thing that exists that people certainly talk about a lot without understanding.
I understand, Your Honor.
I'm trying to understand your interpretation of Black Point and of the Thompson case, where those cases were reversed for because of involuntary dismissal was granted and based upon failure to allege or prove superiority of its lien.
I think Black Point was actually affirmed. On the summary judgment was affirmed. The Thompson was reversed. Maybe I'm incorrect on Black Point, but in Black Point,
In Black Point, we reversed.
okay. I apologize. Black Point,
we
Fannie
affirmed.
Mae.
Black Point assets, we affirm.
There's two Black Points.
Oh, there's two Black?
Black Point, Fannie Mae.
Well, I was not, in Thompson, we reversed.
In Thompson, you reversed. Correct.
In Thompson, we reversed.
In Thompson, you reversed because the court involuntarily dismissed the case. They agreed at trial, the trial judge agreed that it was the bank's burden to prove that its mortgage was superior to whatever interest Jupiter Homes may have had in the property, and the bank didn't prove it at trial, and then the trial judge dismissed the case. It came up to the 5th, and the 5th DCA reversed and said there was neither side proved superiority. It needs to go back to the lower court for that issue, it remanded for a new trial, and it also cited that the bank proved a prima facie case for foreclosure and established the 4 elements necessary to foreclose. That's the Thompson case.
If superiority isn't part of is superiority, in your view, part of a prima facie case?
That's the tough question. According to the law, no, because the case law says in order to state a prima facie case to foreclose, the elements are mortgage agreement, default, acceleration to maturity, and an amount due. So it's not necessarily an element necessary to foreclose, because if you have a junior lien holder, you can still foreclose and take title and have a valid foreclosure action. You established your foreclosure case. You don't have to. They're not a necessary party if a junior lien holder. They don't have any bearing on your case other than to foreclose out their interest. So it's not a necessary element to prove superiority to have a final judgment of foreclosure.
Yeah,
and I believe...
But here, then, that's true. I agree with what you're saying, but then you can't then also then wash them out is the problem, as your judgment does. I mean, if you say, I prove my 4 elements, I get a foreclosure, then you still have to deal with the junior lien holder.
In this case, you can, because they denied that they have any interest in the property. What's there to foreclose out? We have no interest in the property. We have no interest, so that's why they're included in the final judgment, to foreclose out any interest they may claim later on to have had. That's why in the answer...
If they had agreed that they had an ownership interest and denied that you had, that your interest was superior, the bank would have to have the burden of proof to prove that.
I believe that's accurate. And the reason for pleading that way is then the bank can do discovery. What interest do you have? You claim you have an interest. What interest do you have? And then they can use that discovery at trial to disprove that they have any interest and prove that the bank's mortgage is superior.
Yeah, you're putting more faith in some of these lawyers than we do. As this case perhaps points out.
Your Honors, based on the record in this case, I would ask the court affirm the final judgment of foreclosure. The bank put the mortgage into evidence and proved all of the elements necessary to foreclose. Right. If there's any other questions,
thank you, sir.
Thank you very much.
In the pleadings, did you deny an ownership interest?
The pleading said that Orlando
Is it
property...
yes or no? Did you deny an ownership interest?
It's more complicated than that. We denied that they had a superior interest.
Read it. Read the answer.
The answer is simply denied, but I was going to publish to the court the allegation that was, it was met with a response denied, period. Defendants, Orlando Property Acquisitions, LLC. This is on the record at page 25. It's paragraph 14 of the complaint. Defendants, Orlando Property Acquisitions, LLC, may claim some interest in or lien upon the subject property arising from an unrecorded certificate of title recorded as case number 2013-CC-000480-0 of the public records of Orange County, Florida, which interest is inferior to plaintiff's mortgage.
So what part of it, you denied it all?
I denied nothing, but
The answer
understood.
denied, the answer denied it, one word denial,
It was denied as
as to all of it, apparently.
simply met with the word denied.
That means all those allegations in that one paragraph are denied by OPA, correct? Yes or no? Should be an easy answer on that one, right?
The allegation was denied. It's obvious that they're citing to the case record. They have the case citation as recorded in the public records, and then they say which is inferior to any...
And your opponent here today says there's a rule that says if part of an allegation in an answer is correct and is true and some of it's not, you have a burden as the answering party to so state that. Do you agree with that? Do you agree with his recitation of the rule?
The recitation of the rule is correct, but when someone says that X person is a natural person living in Hillsborough County, nobody says, well, I am a natural person, but I don't live in Hillsborough County.
Why not?
Yeah, why not? They do all the time. It might not be quite, that simplistic, but it happens all the time.
In many cases where that is the deciding factor, in this case, they have the certificate of title, they cite the certificate of title, and the principal allegation is that they're superior, and that was what was denied.
I mean, basically, your opponent over there is saying if you'd have simply said, look, we admit we have an interest, you're right, we have an interest because of whatever, but we deny that that our interest is inferior to yours, then you've teed it up for him, or counsel on the other side, him or her, to say, all right, game on as to this allegation.
Well, then respectfully, Your Honor, very respectfully, who's playing games at that point? Because they knew well they had the certificate of title, and they cited it.
If you deny that, if they say you have an interest in the property, you're denying you have any interest in the property, then if I'm the plaintiff's counsel, I say, well, you're saying that I shouldn't even have sued you, you have no interest in the property, so I can go on to something else. Why not? I mean, at some point, if you truly are concerned about your lien being superior or not superior, maybe you ought to clarify it. And I understand it's not you. You just woke up yesterday and decided you're in this case. But,
Understood, Your Honor. The spirit and the intent of the denial is not to deny that,
Spirit of it.
spirit.
So what we have to do is get a
spiritual
crystal
now.
ball and divine the spirit of the denial. I'll try to work that into an opinion, but I can't promise it's going to make a lot of sense.
I would like to offer one thing to put into an opinion. Two things, if I may close. May I exceed by 1 minute?
Well, not a minute, but you got about 15 seconds.
Two citations for the
I know, you were
proposition.
going to tell us what to put in an opinion. Go ahead.
First, asking for judicial notice doesn't cut it. The citation is,
Yeah, but that isn't really an issue teed up in this appeal particularly. Go ahead, what else?
and second,
We'll leave that up to Judge Lambert, since he apparently feels very strongly about that. What's the other one?
Maybe not as strongly as I did a few minutes ago.
What's the other point?
and second is that Hamilton, MDTR, LLC, and Sotshin all cited.
Okay, you've already said that, so we got it. Okay. Your time's up, thank you. We're going to take a